So I want to just, as I said, we have about 25 minutes, and I want to try to cover as much as I can in sort of laying out for you what I see as pitfalls, what I see as areas of over-regulation by communities, and what I also see as over-regulation by municipalities. One thing, I've got some literature up here. Basically, it's 4 or 5 articles that I put together. They're also on our firm's website, but I put them together here if you want to take one. And also, I have a list if you want to sign up. I'm going to be doing some webinars online, like video. And also, if there's any updates or other articles, I can just put you on the email list if you want to sign up. And of course, take a card. So the first thing I think to bear in mind is many of you, I know, face regulation by communities through a rule or a regulation or a bylaw. And those can be passed pretty easily. Oftentimes, as you know, they're passed in the dark without anybody maybe being at a meeting or without there being proper notice or something to that effect. And that's terrible, frankly. But the thing to remember is they might not even be allowed to do that anyway, because what really matters is what your declaration provides. And in the hierarchy of things, and one of my goals is to have you leave here today armed with more knowledge and information so you can ask the harder questions of your communities and the boards, and that you can feel that you have a little bit more information about that. So what really matters is the declaration, and there's a hierarchy. So you could have a rule, you could have a bylaw, but unless the bylaw says that they can do that, and I don't really care what it is, charging a fee, limiting the number of bedrooms, limiting amenities, regulating the gate, whatever it might be, adding a fee, or encumbering short-term rentals. As you all know, most of you probably have properties in communities that existed and whose declarations existed long before the idea of an STR was on anybody's mind. So what I'm finding is most of the time, your declaration is likely wide open for STRs. What the next item to consider is that the declarations, they can be amended, obviously, but it's hard. It's really hard to do it right. You need 67% in most circumstances to amend a declaration. 67%. Imagine 67% of anybody, of anything, any group, let alone property owners, many of whom are not even local. Amending a declaration is a difficult task. So bear in mind that even when you may raise these issues, the associations are not going to be able to correct them overnight properly. And that's why, frankly, they're going to passing rules and bylaws because it's easier. It is something that they can attempt to do at a board meeting or at a committee meeting. So what does it mean if they pass a bylaw or a rule that is not in line with the declaration? The good news is, what it means is the bylaw or the rule is void, flat out void. And we have had some success in taking that position. Some of you may have heard of the case involving the hideout, and that was the very thing that occurred in the hideout. And I'm going to walk you through the basics of that case very quickly. The hideout first threatened total ban on STRs. That was a mistake because what it did is it mobilized the community. They then had a series of extremely long meetings at which they ultimately backed down and said, okay, we're not going to ban STRs. We're going to put in place a number of occupants limit, higher fees, and most importantly for the hideout, a 10 times per year limitation. So you could engage in short-term rentals just 10 times a year. So if you did, that's 10 potential weekends, right? Or 10 weeks or something like that, but only 10 times. They did not do that through the declaration. They did it through a bylaw amendment. Now, as an aside, we challenged this, but the court didn't decide this issue. We contended that they undertook the vote the wrong way. And I still believe we're right, but the court just didn't address it. So for instance, it's a bylaw amendment. The bylaw does not allow for electronic voting. It does for other things, for instance, the board, but not for bylaw. We said that unless the bylaw says it, you can't do it. And there are cases that provide for that. They also didn't have a proper count of who was allowed to vote, which is also a big problem. The court didn't decide that issues, but those are issues for you to think about when there are votes. Just because there's a vote, it doesn't mean that it's in accordance with the documents that provide for how the vote is supposed to be taken. So the hideout then passed this 10 times limitation, the higher fees. So what we did at that time, the community, STR community, contacted our office, and we got involved. We tried to get an injunction, and the court in Wayne County denied the injunction. The reason why is because fees were involved. And when money is involved, so you all know, injunctions are only granted when there's an immediate right to relief, and that relief is non-monetary. So the court argued that it was about money. I argued that it was about property rights, not about money. The court disagreed with Eric Smith on that one. So then we went on and we litigated the case a little bit, and ultimately we filed something called an application for relief. And the application for relief relied on basically two principles. It relied on the planned community law, which most of your communities fall under, and it also relied upon the Pennsylvania nonprofit corporation law. All of these associations are nonprofit corporations, and I think that's important to remember. I think most people don't really think of it that way. But it's just like a for-profit corporation. That means the board has fiduciary duties. The board owes all of the members and owners fiduciary duties. That means they need to make decisions that are right for the community, not right for them. So we filed this application. We used the declaration, and we said the declaration actually preserves the right to rent right up front. It gives the right to rent. Second, there was a restriction inside of the document that talked about only single-family dwellings may be constructed, okay? There was no use restriction. There was a building restriction, but no use restriction. So the other side, the hideout, basically took the position that the case Slice of Life, we all know about the Slice of Life, and I'll talk about that, because understanding the Slice of Life is very important. So they took the position from day one that the Slice of Life governs everything. It's the greatest ruling of all time. They missed the boat on Slice of Life. So we took our points to the court and we said, Judge, look, it only says that you have to only build single-family residences. It does not say anything about single-family use. So even if Slice of Life applied, it would not apply because this is a building restriction, not a use restriction. Well, the judge disagreed with Eric Smith again and ruled against us. So we then left Wayne County and went to the Commonwealth Court. And the Commonwealth Court is one of the two middle-level appeals courts. And we had a nice, healthy argument in front of the Commonwealth Court. We were asked very pertinent questions, but the court got it. And they ruled in our favor at the Commonwealth Court. And the court said, listen, it's this simple. The declaration only contains a building restriction. It contains no use restriction at all. So if it doesn't contain a use restriction, how can the hideout, and they put all of their eggs in a single basket. The basket was only single-family uses are permitted. And the Slice of Life says that single-family use doesn't mean STRs. That was their entire argument. The court said, we don't even get to that because there is no use restriction. It's a building restriction. The court gave us like a 20-some page opinion, maybe even longer, Slice of life was not mentioned a single time because it's inapplicable. It has no application. So we won. We thought that would be the end of it. Thank you. Thank you. On the very last day, the hideout then tried to appeal to the Pennsylvania Supreme Court. The Supreme Court of Pennsylvania, much like the U.S. Supreme Court, doesn't have to take the case. They get to pick which cases they hear. So we opposed that in a very healthy manner, and ultimately the Supreme Court denied that application for appeal. So somewhat fortuitously, what happens is it goes from the Supreme Court, they then send the record, literally send all of the papers. They have to send it back to where it came, so they send it to the Commonwealth Court. I got that notice about 2 weeks ago. Today, as I was standing out at the booth, I got a little alert. The Commonwealth Court just sent the whole record back to Wayne County. So that case now is back in Wayne County, and we're going to take a look at what else we can do for that community. But that model is something that we employ in all cases that we look at, that we analyze. And that is, okay, I understand about the rule, I understand about the bylaw, how did they vote on it? Okay, that's fine, and we need to know that. But the real question, the initial question is, let's see the declaration, let's see the covenants, let's see what it says. And most of the time, there's nothing there that would allow the community to regulate STRs. And I also take the position that even if they could, if they're allowing regular rentals and they feel that regular, and I say regular, non-STR rentals are permitted, where's the language that would separate a year-to-year rental or even a 42-day rental versus a 28 or 29 or 30-day rental? So that's the basic analysis. Now, I mentioned the Planned Community Act and the Pennsylvania Nonprofit Corporation Law. The other aspect of both of those acts is that there is a chance of getting your attorney's fees reimbursed under the Nonprofit Corporation Law. It's not mandatory, but it's possible. It's also possible to get punitive damages under the Nonprofit Corporation Law. So I think you should really bear that in mind. Another fallacy that I want to try to dispel is I've heard from folks that say, well, yeah, it's been like that for 20 years. They've had some sort of restriction, so there's nothing we can do about it. Well, most declarations have a provision. It's usually near the end, and it says something like non-waiver. And it basically just says if there's a violation of the covenant or the declaration, that the passage of time doesn't waive enforcement. Well, that was written for the association to enforce against you, but it works both ways. So, in a sense, you can enforce the declaration against the association. And I don't care if they put in the regulation 4 years ago, 5 years ago, 20 years ago. I take the position, and the Commonwealth Court seemed to agree because they cited to that very provision, and they said, hey, it doesn't matter that they've been regulating since 1974. This provision says that there's no waiver. So just bear that in mind, and to most of this time, I would say that you probably are not prevented despite the passage of time in your individual cases. So even if they were regulating, in the 90s, I think you still could challenge it. So let's talk about deed restrictions a little bit, and also, actually, let's talk about the slice of life. I love talking about the slice of life because the case makes sense if you understand the case. So the first thing about the slice of life is it has absolutely nothing to do with the planned community law, nothing at all. It's about zoning. And under Pennsylvania law, zoning and community law and deed restrictions are entirely different. Been that way for 150 years. And there's no sign that they're going to intermingle, none at all. And that was the lead argument of the hideout in front of the Supreme Court, is that slice of life basically is the bridge. I argued that the slice of life is not the bridge. And the slice of life has anybody here actually read the opinion, slice of life? Well, good news. None of the lawyers that represent your communities have either. So there's a single question that's addressed in Slice of Life. The single question is whether a zoning ordinance that defines family as requiring a, quote, single housekeeping unit, close quote, permits the purely transient use of a property, meaning STR, located in a residential zoning district. That's it. It's all about zoning. In that one sentence, the one question, the word zoning is twice, and it's very specific. And then this is what the court concluded. All on the first page, by the way. For the reasons that follow, we conclude that pursuant to this court's prior decisions in 2 other Supreme Court cases that dealt with group housing, that the purely transient use of a house as an STR is not a permitted use in a residential zoning district, limiting use to a single family home by a, quote, single housekeeping unit. It's very specific. So even if, in this case, the zoning ordinance limited it to just a single family home, it would be a different outcome. It's because of it being a single housekeeping unit. Does anybody know what that might be? It's a very specific thing. It's defined actually in this Hamilton Township's zoning ordinance. So a single housekeeping unit is generally a group of people that live together, cook together, sleep together, get up in the morning, say good morning to each other, and go on their way, and are there for a more permanent period of time, creating sort of a neighborhood. That's as the analysis is here. STRs are not zoning, number one. Number two, I would argue that many STRs are a single family or a single housekeeping unit. They're families, they're friends, they are people that very likely cohabitate together somewhere else. So Slice of Life is not the end of the universe, and it is certainly not a holding that is anti-STR if the person, reading it knows what they're reading. The other interesting thing is, after the case was decided, there was an outside request to submit another brief in favor of the outcome after the case was decided. And the court said, you know what, we'll let it come in, but our holding is so narrow that what you want us to review has different language. And if it's different language, it doesn't matter. The court literally said that. So as we all know, most of your declarations aren't even the same between communities, and none of them are the same as Hamilton Township zoning ordinance, none at all. So Slice of Life is nothing to fear. And if you have a community that's what they're hanging their hat on, call me. I would love to write a nice letter to your community's lawyer on your behalf. And I should say we get involved in litigation. I like litigation. I like to win, but I would prefer to give someone the keys to understanding before we get into protracted litigation. It's more cost effective, and why fight if you don't have to fight? So I always write a very detailed letter outlining why I'm going to win and why they're wrong. And probably about 60% of the time, it works because I'm right. And they're going to have the law, and they're going to look at it, and they're going to likely feel the same way. I'm told I got 5 minutes left, so I want to say, please sign up if you want. Please take this if you want. I've got one more thing I want to talk about. I will talk to anybody about any of this stuff afterwards. I would love to. I have a little booth out there down the hallway some, or we can talk in the hallway here. It's fine. But the other thing that's on the horizon are municipalities. I really think that as the STR, as the association sort of figure out how to address STRs properly, the municipalities, I think, are overreaching. And that is, I think, And they're really overreaching. And I think it's even a little worse because it's a government, they're elected officials, that everybody pays for. To some respects, if you enter a community and you don't understand the rules, a little bit's on you. But if your township or your municipality is out there being overreaching, that's something different. So I've got like 3 minutes left. I'm going to fill them up, every one of them. With a municipality, most of the municipalities are second-class townships in the Poconos, most of them. First-class townships I'm going to set aside because they're a different animal. A second-class township has very limited powers, very limited. Townships and boroughs and counties can only act with the powers that the state has given them, all right? So second-class townships, I mean, I'll tell you one thing. They can't come into your house and regulate your bedrooms, okay? They don't have the power to do that. I'll leave you with this. Second-class townships have basically been using the same form ordinance. So an ordinance in Salem Township is exactly like the ordinance in Lake Township. It's exactly like the ordinance in Jackson Township, Monroe County. They all suffer serious constitutional defects, serious defects under Pennsylvania law for the powers of a second-class township. And when I say serious, I mean serious that there's literally cases about the things that they're trying to do that they can't do. For instance, declaring any violation of the short-term rental ordinance to be a nuisance per se. As soon as something's a nuisance per se, that gives the township the right to just basically enter. That concept fits to a junkyard. It doesn't fit to, putting an ad in, a newspaper for your STR. So the townships are, somebody circulated this ordinance. It's everywhere. It's like an invasive species. It is spread. But it's definitely attackable. So if you face something from your association or from the township, again, I'd be glad to look at the ordinance to see if it's viable. And the other thing I would say, especially with the municipalities, don't let time frames go by. If they say you've got 30 days to correct, get in touch with a lawyer. If it's me, great. If it's not, get a good one. And don't let the time frames go by. Don't just say, oh, okay, no problem. I'll just see what happens. That would be a big mistake. So just if you get that, just make sure you follow the timing. The other thing, since nobody's kicked me out of the room yet, I'll keep going. Notices. When you get a notice from a municipality about a violation, here they come. The notices must identify precisely what the violation is. They can't just give you a notice and say, you're in violation of, our short-term rental policy, period. They also have to tell you what you must do in order to come into compliance. If they don't, believe it or not, that's unconstitutional, okay? So they can't just serve you a notice that's completely, out of nowhere. I've had 2 cases outside of Philadelphia, if you can believe it, where people were renting like their townhomes someplace as an STR. And it was in 2 different boroughs. And in both, 2 different zoning officers. And in both of them, they wrote a letter, said that you're violating our, group home policy or something, group home ordinance. And it's like, a page long. And my client gave it to me, and I wrote back and I said, well, first of all, they have to tell you how to come into compliance. And second, the group home ordinance doesn't apply to what you're doing. It has no bearing on it. So we just wrote a letter. Again, write a letter. I could have done something else, but I didn't. Wrote a letter and resolved. Done. Gone. Done that for a number of communities. Write a letter, and they had a second thought. So I would say stand up for your rights. These are property rights. I say to people, maybe I shouldn't say it, I say this is still America. We still have property rights, and you should assert them. You bought into these communities. Many of these homes are, I know, very valuable. I know you bought them on some of them on the hopes of using them to their maximum capacity, and that's your right to do. So that's actually one of the reasons why I'm involved in this kind of work. It just aligns with some of the things that I believe in.